Hi everybody, welcome to today's webinar from NBS, looking at the RIBA Contracts and Law Report, looking at managing challenges and risk in the construction industry. A little bit of housekeeping. Today's webinar will last around 50 to 60 minutes. Everyone on the call's microphones are muted, but please do ask questions, make observations. You can do that using the question box on the screen, and we will follow up after the session. In terms of today's speakers, my name is Stephen Hamil. I'm Chair today, Innovation Director at NBS. Also joining me will be Adrian Mallison, Head of Economic Research and Analysis at the Royal Institute of British Architects, Rosemary Beals, Contracts Advisor at the Association for Consultancy and Engineering, and also my colleague Kate Foster, Technical Author at NBS. The first part of the presentation will be Adrian going through a presentation of the findings, and then after Adrian we'll have a sort of panel discussion with all the speakers. So over to you, Adrian.
Hi, thanks Stephen, and thank you everyone for joining us today. What I'm going to do is give a quick overview of some of the detail in the RIBA Contracts and Law Report 2022, but before I do that, I'd just like to reflect on the history of the report. So the report began in 2012, and at the time it was carried out by the NBS. It was intended to be a biannual report. We've had something of a hiatus through the pandemic, but working with NBS, the RIBA has produced the 2022 report, and it's useful not only for the findings I'll share with you, but also for some of the insight it gives us about how the industry has coped with what has been a really quite difficult few years with the pandemic and Brexit. So give you a bit of background about the survey. It was available for completion during 2022, between January and April. We received over 950 responses, which gives us a good base on which to make our judgments. Also, and importantly, this was truly a cross-industry survey. We had support from a whole range of professional bodies, and you can see on the right-hand side of the screen there the list of organisations who kindly assisted disseminating the survey. Just looking at who completed the survey, we had a wide range. That included a wide range of work. The people who completed the survey were involved in publicly funded programs, privately funded projects, commercial, but also a third who were involved in residential occupier projects. So a real range there, including some others such as ecclesiastical and conservation work. In terms of moving on from the responses themselves to procurement and tendering, procurement has long been seen as an issue within UK construction, and indeed the UK government have identified it as a key area to help improve construction productivity. Poor procurement can lead to bad quality buildings delivered late, excessive cost, and often by an antagonistic delivery team. Indeed, poor procurement can provide an open door to modern slavery, not least through the provision of construction products. So getting procurement right is the first step towards making a project ethical and successful. And we can see that traditional procurement still leads the way with over a half, 56%, engaging in traditional procurement most frequently. However, interestingly, only 16% of that is pure traditional procurement. The other 40% where the contractor has some design element. And of course, design and build, typically for the larger projects, account for around a third. And then looking at tendering, we can see there's still a predominant single stage competitive tendering, But we can also see other methods coming through strongly. People are using negotiated method and indeed two-stage competitive tendering. Design competitions, which the RIBA help facilitate, is still a minority, particularly compared to other countries. Only 7% of people used design competitions for one or more projects in the previous year. I think one of the issues that the construction industry has faced have been around low productivity. That low productivity is often ascribed to rivalrous working, a readiness to engage in disputes, and a cost-driven, margin-driven approach to construction projects. In some ways, and this ties up with the move towards building information modelling that we've seen take off so successfully in the UK, has been around collaborative working. So the arguments for greater collaborative working are well rehearsed, featured in a number of reports, such as the Megan report. Are we seeing it coming through? Well, a majority are using collaborative techniques in at least some projects, but 43% still do not use any collaborative techniques. That may be because of the size of the project, and we'll come on to that. But some of the text we'd received is that collaborative contracts are often too complicated for small projects. But then on the other hand, people are quite evangelical about them, saying you should only do projects with contractors and clients who are committed to collaboration. So why does collaboration make sense? Well, among those who have adopted collaborative techniques, a clear majority see those techniques as being beneficial. 63% agree that they reduce the number of disputes, and 61% that they improve the delivery of the client's objectives. 37% say that collaboration relies on standardized data. So I think this is quite an important point. Standardization of data through building information modeling and through the use of common data environments makes collaboration easier than ever before. But what our respondents are saying is that that's not a necessary precondition to engaging in collaborative techniques. So, given the benefits, why don't people engage in collaboration? And you can see that there's a whole host of reasons, but top of the list comes clients not wanting to use collaboration in projects, perhaps as a preference for a clear line of sight of responsibility. Collaboration is sometimes, and perhaps incorrectly, seen as confusing that line of sight. And then a third simply say that projects we work on are too small. And that makes a lot of sense when we think about the number of respondents who are engaged in small scale domestic work through the year. It doesn't really make sense to have a full-blown collaborative contract for a small house extension. For those who did adopt collaborative techniques, what form did that take? Well, for some, it's quite formal, such as a formal partnering agreement or a non-binding partnering charter or alliancing agreement. But for almost 3/4, it's a contract that includes an ethos of mutual trust and cooperation. On one hand, you might describe that as quite risky because the nature of the collaboration isn't clearly described and delimited in the contract. On the other hand, you might say that that's a cause for optimism, that people have sufficient trust in one another to collaborate on the basis of an ethos rather than clear description. And I'd be interested to hear in our discussion what our experts think of that. Moving on now to the actual contracts and forms of appointments that are used. This is really a series of facts. This is just what people use, but I've included it because I know there is some interest in what forms of appointment and contracts people use. Well, for professional appointment. Clearly the most commonly used is the RIBA professional services contracts, and then after that is a bespoke contract. So not one that's amended from an existing contract, but written from scratch. And then we see NEC and the two JCT agreements coming through too. Then looking at the contracts, so these are percentages that have used them in the last 12 months, so they don't add up to 100. People do use a range of contracts, and those contracts are chosen based on the nature of work that is undertaken. JCT suite of contracts has been used by the highest percentage of respondents at 71%. That's followed by the NEC contracts at 31%. The same number are using bespoke contracts, 23%, as we're using it in our previous report. The use of the RIBA building contracts, a fairly new form of contract, has grown from 14% in 2018 to 28% in 2022. Just looking back at that 23% that we're using a bespoke contract, I think one of the things this survey has helped to uncover, but it's by no means a unique insight, is that bespoke contracts can often be risky. They are not tested in common law in the way pre-existing contracts are, and bespoke wordings can often be ambiguous, and the true meaning is often only settled through disputes and their procedures. So where possible, I think the RIBA's advice would be use standard contracts if you can. Just to say that that range of contracts, that's very much linked to the type of project and of course the value of the projects. RIBA contracts are perhaps the minnows. They're typically used for smaller projects with a value of less than 250,000, very often residential projects and small commercial projects. JCT are typically of a higher value, just over half of those being used for projects with a value between 250,000 and 5 million. NEC and FIDIC contracts tend to be used for large projects. FIDIC contracts, of course, with that concentration of overseas work. So, general point, it's important to select the right contract for the project you have in hand. And that's partly, but not wholly, a function of the value of the project you're working on. Okay, and when were these contracts, these many different kinds of contracts signed? Well, 3/4 were signed as you would hope they would be before the commencement of construction. A third were, 32% were signed after construction commenced, but before completion, then 2% after completion. I think the obvious response to this is, what's going on? You must sign your contract before work starts. And in a way that's true. But projects can have their own time demands. And if the relationship between contracting parties is such that they're willing to work at risk whilst the legal side is sorted out, that is an option that can and many are taking. Just looking at projects and their progress, what stands in the way. There's a whole list of things here that impede project progress, and these can often lead to disputes. The top ones are employers' variation and the slow pace of construction. They've been there for a while, but the other two in between those are completely new. We've got required construction products not being available, which is around the supply chain issues caused by the pandemic, the bounce back, Brexit, and now the war in Ukraine. And we've seen very rapid construction product cost inflation. And then also, for exactly the same reasons, required construction workers not being available. So these have really picked up in the last few years. COVID-safe working practices was there during the survey period, but we expect that to fall away and to have disappeared and hopefully never to come back. So once we've got those impediments to construction projects, when things go wrong, they go into dispute. So how many people are going into dispute? Well, it's about a quarter that have experienced at least one dispute in the last 12 months from when the survey was running. Given the exceptionally difficult period we've had, I don't see that as pessimistic as it could possibly be read as. And bear in mind too that we've had year-on-year falls in the number of people, or the proportion of people experiencing contractual disputes. The number's still too high, but it's on the right track, and it's on the right track despite a very difficult year or two. Nevertheless, disputes are still too often part of the UK construction, and people see that, perceive that disputes have increased. So there's a bit of a mismatch there between perception and what's actually happening. When did those disputes occur? Well, for those who had disputes, almost 2/3 occurred during the currency of the work, and 1/3 after practical completion. Those figures are really pretty steady over the number of years we've run the report. What's the effect of that? Well, for 2/3 where it's happened during the currency of the work, sorry, for 3/4 during the currency of the work, work has continued, but for 1/4, work on the ground has stopped. So they have a serious effect on the progress of the projects. In some projects, who are these disputes between? Most commonly, it's between client and main contractor, with 76% of respondents reporting a dispute there. 26% of disputes are between the client and the consultant such as an architect, 21% between the consultant and the contractor. Disputes are increasingly likely to be in higher value projects, so a majority occur in projects with a value greater than £250,000, and 17% occur in projects with a value of £5 million or more. So lots of money at stake in those disputes. Given that the responses were about the preceding year, we have up to 12 months about the progress of the disputes, and 47% report that the disputes are ongoing. So that gives us a picture that disputes being expensive, they can stop work, and they can take a long time. So wherever possible, disputes should be avoided. I'd like just to finish up by talking about some new questions we inserted this year. These questions are around sustainability. The UK is committed to fulfilling the UN Sustainable Development Goals and to achieving net zero. Buildings represent 39% of global greenhouse gas emissions, and following some of the work from the Bank of England and some of the work we saw in COP26, obtaining project finance is increasingly contingent on demonstrating sustainable outcomes. So the survey asked whether sustainable outcomes are finding their way into contractual requirements. 43% indicated that they had been engaged in one or more contract that included expected sustainable outcomes. And these become concrete. 32% were engaged in contracts that included measurable sustainability criteria, 23% around operational performance criteria, and 21% engaged in projects that specified contractually embodied carbon criteria. Those last two, operational performance criteria and embodied carbon criteria, are included in the RIBA 2030 Sustainability Challenge. That challenge not only is a commitment to design sustainably, but also gives a method of recording and recommendations for how to measure that operational performance and embodied carbon data. I think it's particularly encouraging to see embodied carbon feature among 1 in 5 respondents. It's often been under reported upon, but given we are in a climate emergency, the way to reduce carbon now, as opposed to over the lifetime of a building, is to reduce embodied carbon of the buildings we're creating, or perhaps better, the buildings we're retrofitting right now. 7% also include reference to the UN Sustainable Development Goals. For those of you who aren't familiar with the SDGs, I would encourage you to have a look online. They give a very broad and international description of sustainability that goes far beyond just carbon performance. With that note on sustainability, I would like to say thank you all very much for taking the time to listen to the findings from the RIBA 2022 Contracts and Bail Survey. Thank you.
Yes, thank you very much, Adrian. And just a reminder that the RIBA report is a free download, and we'll have the hyperlink at the end of the webinar, and also send it in the sort of follow-up emails as well. So now we're joined by Adrian himself from the RIBA, also Rosemary Beals from the Association for Consultancy and Engineering, and my colleague Kate Foster, technical author at MBS. So the first thing I just mentioned sustainability quite a lot in the presentation there, and I was just wondering, how can sustainable outcomes be sort of written into like contractual requirements?
Well, NEC have recently had their own solution to this. They've released the X29 climate change clause, so they set out the climate change requirements which are part of the contract scope, and so you are bound contractually to meet those. They are quite clear that you have to set realistic targets, you know, so that they can actually be met. It can't be anything too arbitrary. And JCT haven't done anything similar to NEC, but they recommend the use of clauses authored for the Chancery Lane project. And the Chancery Lane project has a clause that is specifically to amend the JCT design and build contract. So you can have a look at those also. In respect to the content that MBS has, we have high level performance requirements where you could introduce metrics, you know, like the metrics suggested by the RIBA Sustainable Outcomes Guide. So if you make a notation of all the metrics you want to measure and the targets that you're looking for, this can be then carried over into the contract.
So I imagine you could have sort of like high level targets for the consultancy. They say, I want you to design me a building that hits the following sort of metrics. But then when it comes down to actual things like product selection, thinking of things like embodied carbon or water usage, that can really be tightened up into the specification for that the main contractor works from.
Yeah, absolutely. I mean, the earlier the contractor knows that it's required, the better, because you're not going to get the correct idea of costs if you've produced a budget and then you start introducing these sorts of requirements later on down the line.
And Adrian, you mentioned the 2030 RIBA initiative, and I think there's a really good sustainable outcomes guide that's a free download from the RIBA as well.
Yeah, that's right. So, I mean, hopefully the RIBA, and you can just go to architecture.com, gives quite a lot of guidance in this area. If there is any kind of need to understand what you should be aiming for and when, the RIBA has some good guidance. It includes guidance on how that can be measured, primarily by referring to other guidance. But I think one of the things the RIBA is trying to do is to get everyone together to be aiming for the same thing. And that's not only among architects, clients and contractors, but across industry. And I know RICS too are doing some excellent work in this area, as are the Construction Council. I wonder if Rosemary, you wanted to come in on that.
I was just going to mention that the RIBA plan of work doesn't define sustainability checkpoints, And those sustainability checkpoints are actually referred to in the ACE schedules of services for MEP work. When it comes to definitions, the schedule of services is drafted to align with the RIBA plan of work. And when you get to the stage which deals with developed design, the consulting engineer is to actually complete the developed design sustainability checkpoints. So sustainability can, it's not mandatory, but it can follow through the course of the project.
Yeah. And you mentioned also the Building Safety Act, and I think the primary legislation is now out, maybe not quite there with the secondary legislation, but do we expect to see contracts changing to reflect building on the types of building that are in scope for the Building Safety Act? Kate? Thanks,
Stephen. The initial impression of the Building Safety Act is, there's opinions across the scale. I've heard some people speculating it could be the end of design and build, and some people think it will be, the boon for design and build. There's a lot initially to do with the extension of limitation periods, going quite far back in time, 30 years. The secondary legislation will set out the actual regime in which things will be verified, i.e. the building safety regulator and all the information that's required to verify the safety of a building while it's being designed and constructed and as it goes into being occupied. This is all applicable to what's called in-scope high-rise buildings. And the government has said that the definition could be subject to amendment. So it's a good time to start looking at everything that's come about as a result of the Building Safety Act receiving royal assent. And there's also a number of competency standards that have been released by the British Standards Institute, and these go into the framework of how to, verify that yourself as an individual are keeping up to date and you're not doing work that's outside the remit of your scope of services. And there's a big focus on behavioural aspects of competence, so being transparent, ethical, collaboration obviously is a big topic, as Adrian said, and not being afraid to seek advice from third parties where you're at the limit of what you're able to advise on for your client.
And I wonder, a bigger emphasis on third-party certification, whether that's competencies of the consultant or product manufacturers or installers.
Yeah, absolutely.
Verifying that as well.
Yeah, so they're going to have to, any consultant architects, they're going to have to be really sure that they're covered to do any design, and where they're not, they're going to have to seek specialist consultation and obviously be satisfied that the person that they are getting that advice from is competent themselves. So there is a big burden on keeping yourself up to date and making sure you're not passing off jobs to people who aren't suited to do it, basically.
And I imagine, Rosemary, the consultancy contracts within the scope of services will you be saying what you're responsible for and what you need a specialist, whether it's a fire consultant, whether it's structural engineering, when it comes to building safety?
Well, that's right. There, at the end of the schedules of services, you can pick the expertise that you might need and identify that. And that's quite important, because the client has to know what expertise may need to be brought in, given the type of project that the consulting engineer is engaged on.
Yeah, and I imagine if you do get novated, so you're working for a main contractor as opposed for the client, make sure that the responsibilities match and you're not taking on responsibilities which are beyond your areas of expertise.
Well, that is incredibly important, and we might talk a bit later about standard forms of agreement and the risks and responsibilities that the parties take on, and to actually define those is absolutely crucial, not just in the area that's just been discussed, but overall, because without that clear definition, enormous problems can arise during the course of the contract or indeed afterwards if claims are made.
And that was a theme of 2 or 3 of Adrian's slides, where he showed the use of sort of standard forms, whether that was consultancy contracts or main building contracts, versus the sort of bespoke terms and conditions and moving away from. Well, what would you say the pros and the cons are between sticking to a standard form of contract and sort of moving away from it?
Well, ask the question, why use a standard form of agreement? And I think it boils down to, do you know what you're signing up to? And it's a fairly fundamental question when entering into any sort of agreement. And I think that depends on whatever the value or complexity of the services happen to be. And it's surprisingly common that people can't answer the question. And you have to ask why, frankly. And it's largely because they've never seen the terms and conditions of the agreement, which are going to underpin the services they're going to perform. They may have seen a reference to terms and conditions, or indeed they may have gotten so late in the day they haven't had a chance to really read them or don't think it's really necessary. And certainly from the ACE's perspective, which I thoroughly endorse, you must consider and offer a client, if you can, a standard form of agreement. It doesn't have to be the ACE agreement. I know that the ACE produces its standard forms, but there are plenty of others. And it's a question of choosing which standard form is right for you. And most standard forms, and again, the ACE agreement is a case in point, provides for the addition of supplementary clauses, which can be offered by either the consultant or indeed by the client to deal with the particular services that are being provided. They may be very special and need supplementary conditions, but the idea is that they fall under the heading supplementary conditions and people know that that's what they are. They go beyond the standard, but then they can read those in conjunction with the standard and take a view on the impact that they might have. But so far as standard conditions are concerned, they are produced by industry for the industry. And more often than not, they have been influenced by client input, because there's no good an organization producing a standard form of agreement, consultancy agreement, to offer to a client, only to find that it is just wholly unacceptable. So it's important to engage with clients if you can when drafting a standard form. Again, try to engage the insurance industry, because the services to be provided under the standard form need to be insured. So the ACE, when it produced its latest standard agreement, made sure that the insurance industry was consulted to see whether or not the risks and obligations that are undertaken by the consultant are indeed insurable. Standard forms should produce clarity, and clarity, the case for clarity is really irrefutable. Commercially, it's important that the both parties to the contract understand what they're signing up to, and as the standard forms are used and users get to know them, it makes it far easier to both price for whatever the services are under that form of contract, and to have discussions about how they suit the project in question. And we would certainly say beware of bespoke contracts, because they're unlikely to be balanced in terms of risk or many other issues. And therefore, those signing up to them can find themselves signing up to obligations they had no idea they was actually signing up to. And I think the other thing I'd like to mention is to beware of incorporation by reference. And incorporation by reference is essentially referring to a document, and it can be a standard form, intended documents, but not including it in the documents, then there is therefore the data is in fact incomplete. And to allude to incorporate standard terms by reference can lead to a misunderstanding of what's been agreed, potentially the risk of unlimited liability, and a lot of other issues. I'll stop there.
Adrian, I remember when you were presenting on this topic, there was also that sort of sense of maturity that the likes of the JCT, NEC, RIBA contracts have. They've been tested in court, and you know that as sort of rock solid clauses.
Yeah, I mean, my reading's fairly crude, but just based on the comments and the survey running for a number of years. I mean, very crudely, contracts describe responsibility, risk, who has it, and how much they're getting paid to do it. If you're using the standard form, that tends to be done in a fairly transparent and well-established way, and other people have done it in that way, and other projects have been run in that way. If it's not the standard form that you're being offered, then ask, what is the risk? What is the responsibility, the non-standard risk and responsibility that I'm assuming? Do I know it, and am I being paid enough for that? And if you can't really answer those questions, then you might want to think, who's benefiting from using this non-standard form? It's a crude summation, but that's what comes across to me.
I think that's absolutely right. And I think that although it may be a hard thing to do, if you really don't know, you should be prepared to walk away. And certainly, if there is anything that appears unusual, to consult at the very least your insurer, if not a lawyer. I don't want to be seen to be promoting lawyers particularly, but certainly what you can't afford to do is to find yourself uninsured.
And we talked about standard forms and the importance of specific wording and clauses, but at the same time, when we talk about the collaboration aspect of the presentation, and the wording, I think it was the ethos of mutual trust and collaboration.
Cooperation.
How can that be written down into something really tangible? What are examples of contractual collaboration techniques?
Well, that's interesting. There's it sounds a bit vague legally, without a doubt. And I'm only aware of 2 or 3 cases which have looked at it in general terms. And certainly one of those did intimate that, in fact, it's really fairness, undertaking the project in the spirit of fairness, which is something that actually existed before the word mutual trust and collaboration sort of came on board. So in that respect, it's really a question of the parties acting towards each other with the common aim of, at the end of the day, delivering a successful project. And it's not just these clauses that you see in those contracts now talking about mutual trust and cooperation. You're seeing other clauses which work quite well with that ethos, which is, for example, the early warning clauses that you see in NEC. You see them in ACE conditions as well, where if there is an incident or something that has arisen or may well arise, which will affect the delivery of the project, you flag that up. You'd think that that was something that would you do as a matter of course, but folk don't always work like that. And to be able to raise these matters early, discuss them in a reasonable and rational way, knowing what outcome you both want and working out how you're going to be able to deliver that outcome, that's all part of it. And that makes enormous sense. And I think that more people are realizing that now. It's in everybody's interest not to be antagonistic, but to work together to see how the project can be best delivered. And that, of course, you can take a step back to the parties discussing risk and issues in relation to the project at the earliest possible point in time before they get to the stage of issuing necessarily contract documents. But seeing what the strategic aims of the client is, how they can best be delivered, bringing others on board who might be involved in the project and talking it through. And again, that makes total sense. And it's all collaborative. It's not rocket science, as they say. It's just good business practice. And I think that's the message to keep hammering home, that don't try and score points. Look to see how you can both win.
Yeah. Hi, Adrian, you just muted off there.
Yeah, thanks. Sorry. I just wanted to add to that. I think given when the survey was run, it was looking back at the pandemic, and my view is it could have gone one of two ways. It could have become highly antagonistic, highly disputatious. But overall, it seems, of course, there are still problems, but overall, it seems that as an industry, the construction industry came together as best it could to continue to deliver in a very difficult time. So yeah, just to agree with your sentiments, Rosemary, that it doesn't have to be rocket science, but it does need predisposition to both parties winning rather than scoring off each other.
And in terms of clarity of understanding, especially of responsibilities, there's one slide that I think was as high as 85% of the contracts used had some element of specialist subcontractor design. So the traditional architect or building services engineer not going as far as detailed drawings or detailed specification. How, maybe ask Kate, how can those design responsibilities really be set like rock solid in the contractual documents?
Thanks, Stephen. Well, I think the designers first need to set out exactly what they're going to do themselves and what they're going to want the contractors to do or another third party. I actually came across a case to do with contractors design, and it's back from 2012. And basically there was a lot of issues with what had been agreed, and the first error was including within the prelims that there may be a contractor designs portion. So that wording in itself is a little ambiguous, and apparently through the course of the dispute, multiple different contractor design packages were meddled with in different ways, with the architect sort of saying they wanted the contractors to do it, but then liaising with the specialist subcontractor, so really blurring those lines on who's actually responsible and what the intent is. So I think getting it clear from the start what it is you want to do, and then setting that out in your documents with the employer and with the contractor so that it passes on, and not being afraid to ask if you're not sure what's happening, basically, and get the clarity you need in writing, preferably.
And I imagine for those contractors design portions, having a really tight description of the performance that's required and how that performance is going to be verified so that you get the outcomes that you want.
Yeah, absolutely. That needs to be clear, and the information passed on, and you need to think of a way to verify that, so that you're happy when you hand over the building that everything you've stipulated that's down to somebody else has actually been completed in that way, and it can be verified whether during the installation or after the fact. And
just maybe the last question, maybe to go to Kate and Rosemary. I'm just going to look at the stats again. I was scribbling notes when Adrian was presenting, but there was a stat around 33% of building contracts were signed after construction had started, and I think out of everyone that took the survey, about 27% had at least one project last year that went into dispute. Is that what you'd expect, or are you looking at those stats thinking, wow, that's terrible, or I expected worse? What do you think?
I'm not surprised. I'm not surprised at all. It happens all too often, especially where a client wants to get cracking early and just puts out some documentation and says, price this and crack on by the end of the week or whatever. But it is quite concerning, and there is case law to say that sometimes you could find yourself in a situation where you think that a contract has not yet been signed, but in fact, a contract has actually been entered into. It all depends on what has happened. And I think that is why it's extremely important that you do sign before you actually commence the services that you have agreed to deliver. Because otherwise you might find yourself, in fact, engaged on terms and conditions you just didn't expect. And there is the other side to it, that you've got to make sure that everything that forms a part of the contract is actually incorporated within that contract. And it's no good having partial terms and conditions and then a few letters following on later and something else following on after that. It's not good practice. And it may not, if you look at the documentation in the whole, actually deliver what was expected to be delivered. So I think it's a message well worth hammering home time and time again. Do sign your agreement before you start delivering the services, and make sure that that agreement contains everything that is to form a part of that agreement.
Yeah. Kate, any final words on that one?
I mean, I think in an ideal world, we would all love to have signed a contract before entering. I think sometimes there's a bit of bargaining going on as the job's going to site, and you know, maybe the client or the contractor's not happy to sign it off at that moment in time, so they start work at risk, like Adrian was saying, on the understanding they'll resolve it at a future point. But if they do get into a dispute over what the terms should actually be, it's how then do you draw the line in what the contract terms actually are versus what hasn't been entered into. So absolutely, you're 100% better off signing it before entering.
Yeah, I was thinking, remembering the name of the case now. It's probably 6 or 8 years old now, but it was a case called Malcolm Charles against Crispin. And that effectively held that just because one party believed that there was no binding contract, there's no guarantee a court would take the same view, which could cause an awful lot of problems.
Well, I've got 3 or 4 more questions, but I think we're just about run out of time. So that's flown by that discussion. And just to take this opportunity, Adrian, Kate, Rosemary, to thank you for your time, and thank you very much.
Thank you.
Thank you very much.
Thanks.
So thank you everybody for taking part today, all of the panelists. If you are interested in the 2 free downloads that have been discussed, the contracts and law report, and also the RIBA Sustainable Outcomes Guide, you can download both of these reports, these documents, at architecture.com, or just search Google for them, and I'm sure they'll be in the top couple of hits. If you'd like to know more about NBS, in particular the NBS chorus, that can sort of help your practice produce robust preliminary specifications, which are obviously part of the contract documents, thousands of template clauses and guidance for architecture and engineering. Please visit our website, thembs.com, or again, Google NBS chorus. But if you'd like to know anything more about the topics discussed today, the reports, the NBS offerings, pop a message in the chat if you'd like to know more. As mentioned, visit thembs.com to find out more information about how NBS can help you on projects. Any questions at all, also just drop an email through to the email address on the screen at the moment, info@thembs.com, and our website, thembs.com. Thank you very much. Bye-bye.